Hello, everyone. My name is Flynn Scott. I am the Manager of Regulatory Services for the Town of Newmarket. In an effort to receive additional feedback from our community, my team has prepared a brief webinar presentation to highlight the proposed bylaw regulations for personal wellness establishments, or PWEs, as I will refer to them today. So looking at the agenda, today we are going to review the licensing framework being proposed for PWEs. I do want to emphasize that we have simplified the provisions using plain language or bullet form, and we'll walk you through each of the different sections. But it is important to note that we will be providing a formal copy of the draft regulations once finalized early next week, which will include any and all feedback received following today's webinar. So before giving you the formalized draft regulations, we wanted to just go over them, talk about their intent and how they will be applicable to this classification, receive your feedback before finalizing that draft, which will go before council at the June 16th special committee of the whole meeting. So when we talk about the purpose of this webinar, of course, we want to provide any and all stakeholders or members of the public that have expressed interest with a first look at what some of the regulations are. So which direction are we going once council had provided direction at the May 3rd committee of the whole meeting to move forward with option 1, which was to identify a new classification, the PWE classification, and repeal body rub parlors from the Town of Newmarket bylaws. So I'm going to then further explain what the proposed regulations are and how they are applicable. And then finally, encourage feedback from, again, any relevant stakeholders or members of the public with expressed interest. So we're hoping to present the final draft in plain language. I'll walk through them today. And then we're hoping to get additional feedback throughout this week, which can then be applied to the June 16th special committee of the whole meeting of council. So getting right into it, we'll start with some of the definitions being introduced. So what is a personal wellness establishment? Well, the definition being proposed means any premise or part thereof where an alternative massage is performed, offered, or solicited in pursuance of a business. And then, of course, we have to define what is an alternative massage. Essentially, an alternative massage is any person offering or performing a massage that is not performed by an RMT or a regulated health professional. So if you don't hold that level or standard of designation, then this classification would apply to you if you are performing a massage on another person in a business setting. And finally, we define a personal wellness attendant, which is any person who performs, offers, or solicits an alternative massage at a personal wellness establishment. So when we talk about application requirements, and we know now who requires a license based on the definitions, we get into more specifically some of the application requirements of that owner or operator of a PWE. And so one important note is that the town's business license bylaw 2020-31 is already adopted by council. It's a bylaw for the general licensing framework of storefronts within our community, and there's certain classifications identified under this bylaw. The new PWE classification will be introduced and essentially live under this classification and under this bylaw and licensing framework. And so as a result of that, there are pre-established provisions already adopted by council that still are applicable to PWEs in the classification being introduced today. So when I say that, this includes things like Section 3, general regulations, that speaks to any person conducting business or an owner or an operator of a business identified within the bylaw must apply for and obtain a business license in order to operate. We also have general provisions requiring that any business required to be licensed under the bylaw complies with all federal, provincial, and municipal laws. We also have advertising requirements, so where they can be advertised, making sure that you're licensed before you're advertising, and Certain classifications require that the license number be posted and so forth. So we already have those pre-established in our bylaw, and they are still applicable to the PWE classification being introduced. Similarly, Section 6 is the application and renewal requirements. I've included one bullet point here, just saying that this is the location of the bylaw where general application requirements for the person applying, so the business owner or the applicant, this is the requirements established. So things they will need to do or provide documentation in order to be licensed. And finally, I've highlighted Section 7, which is the section that speaks to the suspension, cancellation, or refusal of a business license. And so any owner or operator that fails to act in accordance with the law and with honesty and integrity may have their business license either suspended or revoked or refused if it's at the application stage of the process. And I've included one other bullet, which is a very strong power, again, already pre-established in the licensing bylaw, which is the ability to post a notice on an unlicensed or suspended premise. So if there is a business currently undergoing enforcement action, say they unlawfully obtained a business license, providing false information, they slipped through the cracks, and now they're operating. And we know that what they're operating or advertising aren't services that have been approved by the town to do so. What we can do is either suspend or revoke that business license. And similar to liquor license or the AGCO, where a premise who has a suspended liquor license may get a notice posted on their door for the public to understand what's happened, we can do something very similar. So this will empower the community to be aware of which premises are under investigation or aren't lawfully licensed by the town. And we can post a notice, and there are enforcement actions tied to this section where any notice removed receives an automatic fine as well. And so it's a very strong provision to have that is public facing to let our community know that the town is aware of ongoing issues at an unlicensed premise or a suspended licensed premise, and we are able to take the appropriate steps to remedy that. So moving into the application requirements. So when we get to section 8.6, this is the specific regulations that pertain to PWEs or the PWE classification. And so under this section, we have introduced just some general requirements. So as part of the application, the owner needs to submit a floor plan showing the location of every room, entrances and exits, and so forth. Also, under section 8.62, the business owner or applicant needs to submit a copy of any lease agreement with the property owner. And it goes one step further to ensure that the property owner is signing that they understand and are informed of the nature of the business being conducted within their premise. And that is important. And we'll speak to it a little later, but it's important for the property owner to be well apprised of the business being conducted, because there is an opportunity to take enforcement action against the property owner if compliance efforts fail with the business owner. So this is something that will be strengthened in our bylaw as proposed today. So section 8.63A establishes requirements for any attendants performing massage services in a PWE. And so similar to the town's other licensing bylaws, we are placing the onus and responsibility on the business owner directly rather than on the staff, or in this case, the attendants. We're not proposing to license each attendant, but instead require the business owner to ensure their staff are operating lawfully and in compliance, and ultimately holding the business owner or applicant liable at the end of the day. And so if any violations are documented, it's the overall business license of the establishment that becomes jeopardized. So it's not going after each individual attendant. Instead, it's holding the business owner accountable, and any actions or operations being conducted under that business license now jeopardizes that business license if any of the staff are doing anything unlawful that contradicts the license that was issued to them. And so I just want to comment here that this also aligns with the feedback we received that typically under the previous body rub parlor classification or any other holistic classification in other municipalities, feedback received is that it's typically the attendants that are being targeted for the enforcement action and not the business owners. And we also received feedback from our businesses here in town that there's often a turnover of staff in certain alternative massage businesses. And so we want to ensure that we're not creating layers of red tape for our legitimate and reputable businesses of having to license each and every attendant as they come through, or any part-time attendants that might be coming through. And so again, the overall focus is to really hold the business accountable, which mirrors every other newly introduced licensing framework at the town of Newmarket. We've done that with taxis, we've done that with tow trucks, we've done that with several other business classifications, and now we're here to present it for PWEs as well. Oh, just going back, sorry. Section 8.63B. So this is the section which aligns with Council's direction to move forward with option number 1 that was presented at a previous Committee of the Whole meeting conducted on May 3rd, 2021. And so this is the requirement that all attendants offering an alternative massage has some form of training, some standard of training is required. And so what staff did was we consulted with our local business owners. We got in touch with over 30 of them. And we received great feedback. And that feedback was that accredited colleges throughout Canada offers a, slightly reduced training program in comparison to RMTs. So they offer a 12-week training program rather than, the 2,200 hours that an RMT would require as part of their licensing certification. And so while we consulted with local business owners within our community, most of the businesses advised that this requirement would not negatively impact their business. So we heard from several business owners that this classification actually wouldn't apply to them because they only provide massage services by RMTs. Or we heard that several of the local businesses or spas within our community do already have that threshold of training, and that their attendants did have that level of training, and this would not be an issue for them to meet that standard. Now, I will comment that most is not all, and there are businesses with some instances where some of their staff may be impacted or all of their staff may be impacted. This number is quite low, but I will take this time to emphasize that if there are any local business owners reviewing this and seeing this provision and believe that they will be significantly impacted, we welcome your feedback to please get in touch and further discuss with us this week before we go to council to propose these draft regulations. And so there is one slight exemption, but more so an alternative option being proposed to the training qualifications that I just discussed on the previous slide. And so under section 8.63C, this section really recognizes that not all practices of alternative massage are recognized in Western culture, and therefore may not be offered through an accredited school in Canada. And so we also recognize that new practices may emerge in the coming years, and we don't want to disqualify any reputable or alternative practices from being able to offer such services based on the fact that there isn't an accredited program here in Canada which can give them some form of training qualifications as identified in this bylaw. And so for this rationale, we have proposed an alternative option for training qualifications to be met, but I do want to emphasize that this provision is extremely unique to Newmarket. So what we've done is taken what other municipalities have done previously, but we've altered it just slightly. And what I mean by that is that other municipalities have created something similar, but more general in nature. And put simply, they recognize certain holistic associations and their certification. So they'll say, as long as you belong to this association, you provide the certificate or the documentation, and we'll vet it and we'll accept it. However, we did receive extremely strong feedback from both community advocacy groups and other municipalities that we consulted that illegitimate certificates are often being produced to satisfy that municipality's requirements. And so we've proposed this provision to be a little bit different. And the important piece is that this section will only apply to a practice where no accredited program exists. So for instance, somebody couldn't come and say, I don't have that 12-week accredited certification from a recognized institution in Canada. Instead, I have, this certification that I received from an online program or something else. That wouldn't be acceptable. They would actually have to demonstrate that the services they are willing to offer or trying to offer has no option to receive training from an accredited program. And a good example of this is actually osteopathy being performed by someone other than a regulated health professional. So there are legitimate organizations out there that do conduct training for osteopathy, but there is no accredited program in Canada that recognizes this unless you go to the extent of a regulated health professional. So there is an in-between there and a gap from an accredited program. So this is the provision that would allow any alternative practice that hasn't been recognized by an accredited program to have alternative training options available to them. And so we recognize in everything I just said that there are opportunities for loopholes for persons to falsely obtain a business license, saying that they're providing one service and then providing another. We have seen this in Toronto, in Hamilton, and other municipalities we've been able to consult with to date. So the final section is really our strongest, and I want to put a lot of emphasis on this. So prior to issuing a business license, there are options to further vet an application to ensure legitimacy, that the services advertised match the services being provided. And so we talk about things like an interview with the owner or any of the attendants to ensure that they are qualified. So we can conduct a bit of a vetting process of an interview to question them on their resume or the certificates they have to make sure that they are obtained from a legitimate source. Second, an on-site inspection can be conducted to verify the details of the application, ensure the floor plan and what is being offered, the setup, meets the standards established by bylaw. And finally, number 3 is the most significant provision. And I don't want to gloss over this provision at all because it is a really powerful tool that we've recently been able to identify and that staff believes will be great in terms of enforcement action and ensuring legitimacy of all business practices here in town. So I do want to share that I have personally spoke with YRP's superintendent for one district here in the town of Newmarket regarding options for strengthening the partnership between the town's licensing division and York Regional Police. And very similar to how the Alcohol and Gaming Commission of Ontario vets liquor licenses or liquor license applications through York Regional Police, the town will also be vetting PWE applications through York Regional Police as well. And so anytime an application is received, we'll actually be contacting our community partners. This may include public health as well. But in speaking directly with YRP, we are able to vet our applications through York Regional Police in order to understand past history of the business that is being that's being applied for, in order to gain any relevant information pertaining to the types of services being provided. And so any relevant records will be shared, and this information will be evaluated by the town's licensing division to determine if the business plans to operate with honesty and integrity. And that will be by looking at past history and seeing if there is any information on that location that may say otherwise. And so this bridge of information sharing will be invaluable for ensuring that businesses operate as intended and described under their application for a personal wellness establishment business license. And again, I really can't emphasize enough, this is a very powerful tool, and it is a big win for the town to be able to vet applications through the police in order to understand past history or understand if this business is in fact operating with honesty and integrity as described in their application. And I know I switched slides, but just to summarize that last point, I do also want to emphasize that that will give us the power to either deny the license up front, refuse it, or suspend the license if future information is provided. So when we talk about the requirements of a business owner, so section 8.65A ensures that a list of all attendants is kept up to date. So anytime new staff are brought on or into the location, that list and the requirements we've identified on previous slides of what needs to be provided, the name, address, phone number of those attendants, ID being provided, that's all up to date. And the onus is on the business owner that anytime a new employee comes forward, they have the onus, or they need to come forward and provide that information to the town. Otherwise, enforcement action can be taken, and we will do so. Section 8.65B requires that records be maintained. So you need to maintain the records of who is the attendant providing a service on which date, which time. We require that the records be kept for 1 year and that they are produced upon request. And we are requesting that a medical pre-screening form be filled out by any persons receiving alternative massage from the location. And this is feedback we received from our local business community that nearly all of them already do this. So adding this additional layer in our bylaw will just further enhance the services being provided in our storefronts already. Section 8.65C and D speaks to ensuring that no sexual services are being provided and that attendants are fully clothed when providing those services. Section 8.66 is a requirement to ensure that the business name and certain information is included on all advertisements of the business. And so where a sign exists in the town that you may see right now that says, massage and then a phone number, will actually require the business name as identified on their application or business license to be advertised and the appropriate information pertaining to that business. So we are increasing the standards of the signage that these storefronts will be required to demonstrate as well. We also received feedback from local business owners that advise that the hours of operation being proposed do not impact them. Again, if anybody is watching this and they feel that their business would be impacted by these hours of operation, we do encourage your feedback as well. And finally, through the application requirement of providing a floor plan, as I previously discussed, we can also require the main entrance access be provided and identified to customers. And so this entrance will be properly signed, and the intent is to ensure that there's no customers going through any back entrances, alternative doors that are intended for staff only. The front of the store or any of the access points, and there could be many, they have to be properly demarcated to express that that is the entrance or access point for that storefront, that business of the PWE. So that is just a high-level summary of some of the regulations we are proposing. Again, it is in draft form. And so when we talk about next steps, we're hoping to take the feedback received from today's webinar, once you've had a chance to watch and view this. We're hoping to receive feedback starting today, going up till the end of the week, June 4th. And we do recognize this is a very tight timeline, but unfortunately, we do have our report and the draft regulations due on June 7th in order for the agenda to be posted for the special committee of the whole meeting scheduled for June 16th, 2021 at 1 p.m. And so if you would like to be involved or provide additional feedback, my team are happy to meet one-on-one at your request. We're happy to receive any statements, whether that's through meeting, a virtual meeting, or whether that's through written submission. But please, we welcome any and all feedback from anyone, whether you've participated previously or you're new to participating today. Please send that feedback or request for a meeting to licensing@newmarket.ca. And we are requesting that be received by no later than June 4th at 12 p.m. And again, that's to meet our deadlines in preparation for the June 16th Committee of the Whole meeting. And finally, if you're not able to make any of those deadlines, or you would like to be a deputation for the special committee of the whole meeting, you can send that request to clerks@newmarket.ca, where you can either submit written form or an oral submission as being a presenter at the special committee of the whole meeting on that date. So hope to see you all out there. Very interested to hear additional feedback, and we welcome it. We understand it's a tight timeline, but with your feedback, we can get some great regulations drafted before council in order for them to review and make the best and most informed decision that they possibly can. All right, I hope you have a great day, and thank you for taking the time. Take care.